Good evening, everyone. It's good to have you back. So we are going to start Company Law 2 as part of your Company Law class. So what I'm going to do is to lock everyone. If you need to talk, you raise up your hand and then I will release you so that we don't have unintended noise coming into the class. So just a minute. Yeah, so we would like to start with the corporate finance in Ghana, the law of financing the company. Now, when we are done with that, we will then go back and discuss membership. And after discussion of membership, then we come back to directors so that they will fall in right places. So before we start our discussion of the law, and then before I share the screen, I would like to first of all remind you of certain basic things you have learned already. Now, when we started this course, we discussed what we call the models or the various forms of business organization. That is the various vehicles which a person can use to set up and run a business. We saw various types, including sole proprietorship, incorporated private partnership, trusts. We also look at the cooperatives, and we concentrated mainly on incorporated company, which is governed by the Companies Act 2019, Act 992. Now, with respect to incorporated company, we have also looked at various types. We look at companies which are limited and then companies which are not unlimited. And with respect to companies which are limited, we have talked about company limited by shares, in which case the liability of a member is up to the amount of money the member has put in the company in proportion to the shares that he or she has been given. In other words, a member of a company limited by shares would only lose the investment that he made in the company by way of the shares that he purchased. In the event of the company winding up, in the event of the company becoming insolvent or being unable to pay its debts and liabilities as they arise or as they become due. Now, beyond what you contributed by way of shares, which you will not get back because the company has actually fallen on hard times, nobody can actually ask you to make any further contribution as it were. So that is the sense of saying that you are in a company limited by shares. Now, with respect to company limited by shares, we made the point that we have two categories. We have a public company and then the private companies. So company limited by shares, which are public companies, and then company limited by shares, which are private companies. And with respect to the differentiation between these two types of companies, we noted that when it comes to raising funds, private companies have got a number of restrictions. For example, a private company cannot make invitation to the public to come and subscribe for its securities, its shares, its debentures, and so on. And again, a private company can also, if you're a shareholder in a private company, you can also not just transfer the shares. There are restrictions on transferability of shares. Depending upon how the constitution of the company is crafted, you may need to get approval of all the shareholders and so on before you can transfer your own shares to another person. That is for private company. On the other hand, public companies do not have any such restriction. That is to say that if you have shares in a public company and you are no longer interested in having shares in that company, you can easily offload your shares by transferring it to anybody who is interested to buy your shares. Again, where a public company is desirous of raising more funds through the issue of shares or the issue of debt instrument known as debentures, all that they will do is to do invitation to the public, to call upon members of the public who are interested in making subscriptions, or who are interested in actually acquiring shares and other securities which the company have available to make such move. Now, that is very important. And as we discuss corporate finance, we are talking about the various means, the various options which are available to the company to actually raise money. Because mind you, when a company is incorporated, it needs funds to be able to run, especially complemented by shares. And that is why in the repealed Companies Code 1963 at 179, there used to be a provision under section 27 and 28 to the effect that if you have a company limited by shares, it was not enough for you to have acquired certificate of incorporation. You needed to also get certificate of commencement of business. And before certificate of commencement of business could be issued under the repealed law, you needed to have satisfied what we call the minimum capital requirement for a company limited by shares. So certain amount of capital have been prescribed, which a private company limited by shares must raise, and then which a public company limited by shares must raise before it could be said to be ready to actually commence business, as it were. But then, as we indicated last semester, that under the new law, that is Companies Act 2019, Act 992, there is no requirement called obtaining certificate for commencement of what business, as it were. And for that matter, the minimum capital requirement is no longer mandatory. But of course, if you have a company limited by shares, you definitely need to raise some money. Otherwise, what is the point of being a company limited by shares? And as you will notice very soon, as we start the full discussion of shares, you will notice that shares are not issued for fun. Shares are issued as a way of raising money. And for that matter, when shares are issued, certainly money should come to the company. Another point I would like to bring to your attention is this. Where a company is contemplating raising funds, raising money, what options must the company consider? Two main options are available. What we call equity or shareholders funds, and what we call loan or creditors funds, as it were. Now, with respect to shares or equity or shareholders funds, when the company uses that option, it's going to be a very long-term financing, and the company does not have to pay any interest, because those who have been given the shares have made investment into the company. And when the company makes good profits, they will also get their due share by way of dividends. So that is really good for the company. However, the challenge may be that if the value of the company is not high, maybe if the investing public do not have no confidence in the performance of the company or in the projected performance of the company in the foreseeable future, they may be not very much attracted to put their money in the company by way of acquiring shares, because every investor would like to calculate and know the projected returns and any feasible risk associated with a particular investment that he or she would like to make, and so as to also ask himself, do I have a significant risk appetite to actually go on this particular path of investment? On the other hand, the company may want to settle for loan capital, in which case, instead of the company attracting people to come and invest and get a permanent stake in the company by way of shares, the company would rather be looking around for those who have money and are prepared to lend the money to the company in return for interest as will be agreed upon. And for those people who are going to loan the money, they do not have a stake in the company in terms of the profitability of the company. All that they're interested in is to ensure that the money that they are putting in the company will be in a position to pay it back together with the agreed interest. So that is the loan capital. And the typical one is what you call like debentures, long-term debt, and so on. So we will come and discuss that after discussing shares. But in terms of the implication of the company going in for creditors or lenders funds instead of share funds or equity, it is this, that whether the company makes profit or doesn't make profit, the company must pay the agreed interest and then the principal. And the company could also risk losing some of its assets, especially so if the particular loan was arranged in such a way that the company had to give security to the person giving the money to the company, so that where there is a default on the part of the company, then the lender or the creditor, the venture holder, as it were, could easily realize the security, would easily take steps and have assets of the company sold in satisfaction of whatever the company is owing that particular person. So that is what you should keep in mind. But of course, for you as the creditor to or the lender, much as you have an guaranteed payment of your principal and interest, you may also become jealous of shareholders when the company has really prospered and is making so much profits and its assets have actually grown and all that, meaning that the company is on the trajectory of irreversible prosperity. But you being a creditor or shareholder or lender, apart from you getting your money paid back and agreed interest, you have no other no stake in the company. Okay, so having said this, we will start discussion of shares, unless someone has a question on the introduction before we start the discussion of shares. But before we move on, I think anytime I'm teaching this topic to students in company law, I try to encourage them. With respect to what we call, the book. I don't know if there's a book by someone called a book by the Rich Dad, the Poor Dad. I don't know if you've read that book. It is a very useful book which actually encourages us to be serious in thinking about investment. So the book will simply just tell those stories about how you start small efforts of investing, and gradually your investment will be growing, and you wake up one day and you have significant wealth created without you even thinking much about it. So let's look at it this way. Supposing you have 1,000 Ghana cedis, right? Let's say 1,000 Ghana cedis is what you have. You try and look around. Is there company which I think is doing well, and in the next medium to long term, its performance is actually on saleable. It will continue to be doing well. So let me buy shares in those companies. You buy shares in those companies, dividends are declared, you get the dividends, don't spend it. You need to buy more shares and all that. And then you look around, do you have some 2,000 Ghana cedis somewhere? Okay, let me buy treasury bill. At the moment, it's doing about 27% or something like that. I'll not do a long term, just 91 days. The money come, I look at the trend. If it's good, I lock it up again. So with very small amount of money, but just by diligence and prudent personal management, you'll be growing your money bit by bit. And in no time, you will see yourself becoming very wealthy in your own way. So I encourage you to do that if you don't have shares. How many of you have shares, by the way? Can you show by hands? Those who have shares, can you show by hands? Shareholders, let me see. Okay, good. One person has shares. Oh, only one. Okay. Anyway, I'm also happy to tell you that I'm also a shareholder. And I'm actually one of the top 5 shareholders in one of the banks in the country, but I won't tell you. Okay, so Prof. No, Francis is also a shareholder. That is good. Okay, good. Those who don't have shares yet, I encourage you to do that. But before I move on, let me share one of my moments of regret with you. And that has to do with when MTN, Scancom, was doing its, was it IPO? Yes, initial public offering. I know about how many years ago? It's about 4 or 5 years ago or so. And they were inviting members of the public to subscribe for their shares. I responded, but I didn't take it too serious. So I think I bought just about, is it 3,000 cedis or 2,000 Ghana cedis? And it's one of the decisions I regret so much. I wish I had purchased 100,000 Ghana cedis, because if you look at how MTN is doing well with respect to its mobile money transaction also data, those who acquired a lot of shares, I'm sure they will be reaping their investment. Okay, so having said that, we want to come back to our topic for the day, shares. And we would like to understand what shares are, the nature of shares. We'd like to explore basic concepts like the concept of no par value. We'd like to discuss payment, issue of shares, payment of shares, types of shares, the rights which are associated with shares, and also certain restrictions which are imposed on the company regarding the money the company has raised from issuing shares, what we call the doctrine of capital maintenance. So these are things that we'll be exploring in discussion of shares. So in our legal framework, that is the Companies Act 2019 Act 992, Part F addresses shares. So first, what are shares? In terms of definition, shares basically refers to the unit of interest which a person has in the company. So the unit of interest you have in the company is what will be the shares that you have. So mind you, of course, in everyday language or in ordinary man's parlance, one would say that if you have shares, it means you are a part owner of the company. I mean, in everyday language, that is not wrong. But as you know, in technical language, that is when you come to company law proper, that is a wrong statement because of the doctrine of separate legal personality, which we know from Solomon and Solomon, Moko and Monko, Prestel and Petrodel resources and all that. And we are told that the company is a legal person. It can own assets and so on. So if the company can own assets, then you cannot say that if you have shares, then you are a co-owner or part owner of the company. But we'll simply say that it is your share actually is a unit, right? It's a unit, or if you like, the fraction or the amount of interest which you have in the company. So that is what a share is. The ownership, if I say ownership, I put that in inverted commas because as I've told you, but when you use that, it helps us to understand it readily. So the ownership quantum, ownership inverted commas, the ownership quantum a person has in a company, that will be like the shares. Or put in a better way, the unit or the stake of interest which a person has in the company, that is the shares that that person has got in the company. So let us keep that in mind. Now, if you look at section 42(1), we are told that the shares of a member in the company are movable property. So shares in a company is not immovable, right? Shares are not immovable. Shares are considered as movable property. And what it means also is that, of course, not being movable, the rules which govern conveyance, right? What govern conveyance or transfer of interest in land will definitely not apply to shares because shares is what? Is movable. And again, shares can actually be willed. No, share, if you have a shares, it's actually a property. And being a property, you can actually will it to another person. You can gift it. It's a property. You can give it as a gift to another person. So maybe instead of giving somebody a birthday cake, you can decide to send a letter stating that you are transferring 10,000 shares, which you have in a particular company, to the person as her birthday gift. I know for most of our friends who don't understand shares, if you send that as a birthday gift to someone, the person will not be excited. But then if you say that you have just put in a check of 20,000 Ghana cedis or $5,000, then the person will be very happy because of lack of understanding of what shares are. So let us keep that in mind. So shares is a property, and being a property, you can gift it, you can transfer it as it were. And again, another thing to note about shares is that it is a shows in action. It's not a shows in possession. It's a shows in action, not a shows in possession. The shows is actually written as, if you like, chose, C-H-O-S-E, right? Use the whiteboard. Let me see if this one will write for me. Yeah, so when we say that shares are shows in action, not shows in possession, what it means is that if you're a shareholder in a company, you have a grievance against the company, such as your dividends not having been paid or any other grievance, you don't resort to self-help measures, including going to the premises of the company or seizing vehicles or cars of the company in pursuance of the grievance that you have against the company. You don't do that because shares are not shows in possession. Shares are shows in action. Shows in action in the sense that if you have a grievance, you go to court, you take a legal action to enforce your grievance, to enforce your rights against the company in respect of the shares that you have. So let us keep that in mind. Any question before we move on? Okay, continue. Now we come to the number of shares which a company may have. Now, in terms of the number of shares which the company may have, we have to remember that at the time of registration of the company, when we're discussing mechanism of incorporation last semester, as part of the process, the subscribers, those who are seeing to the setting up of the company, they will be asked to indicate the number of shares with which the company is being registered. So the number of shares the company is going to have is determined at the start of the company when you are registering it. You put the total number there. And that is what section 42.2 is telling us, that the number of shares the company and the rights and liability attaching to the shares are dependent on the terms of issue. So first, the number of shares, the total number of shares a company can have is stated in the registration document with the Office of Registrar of Companies. So let's keep that in mind. And the company cannot issue shares more than the total number of shares which it has registered at the Office of Registrar of Companies. That will be an illegality. And about 3-4 years ago, we had a problem in Ashanti region, I'm sure, with some of the rural banks. There was one particular shareholder who took a legal action against about 1 or 2 rural banks, saying that the company has been issuing shares in excess of the total number of registered shares. And for that matter, the company is indulging in illegality to dilute his share ownership. I mean, the issues the gentleman raised were true. And at some point, the companies involved had to settle the matter out of court and get the irregularity actually rectified. So the number of shares in the company first are determined at the time of registration. However, it is permissible for the company to also pass the necessary resolution in order to alter the number of shares by increasing the number of shares or by reducing the number of shares. So that one is also permissible. We'll discuss that in the course of time. Again, the rights and liabilities. When we say the rights and liabilities, as we said, shares actually signify the units or the amount or quantum of ownership interest you have in the company. And that comes with certain benefits, certain rights. And of course, not just rights, also liabilities, as it were. So, how do we know the rights which are associated with a particular share that you have? That one is also determined at the time of issue. When we say the time of issue, that is when the shares were being given to you. So you will notice that when the company is giving shares to you, it's actually agreement between you and the company, right? It's an agreement between you and the company. So whatever the company wants you to enjoy, whatever responsibility the company wants you to carry as a result of the share, it will be worked out at the time that the shares are being issued to you. So the terms of issue will actually reflect the rights and liabilities that are associated with the shares being given to you. So let us keep that in mind. Now, what that means is that you may have many shareholders in a particular company, and yet the shareholders will not be the same in terms of the rights and liabilities. Just as in the animal farm, we are told that all animals are equal, but some are more equal than others. So in the same vein, all of us may be shareholders, but some shareholders may enjoy certain rights and carry certain burdens or liabilities which are not applicable to other shareholders. And the explanation for that differentiation is what section 42, subsection 2 of Act 992 is telling us, that it is the terms of the issue of the share which will spell out what the rights are, what the liabilities are. And for that matter, as we move on, very soon, we'll be talking about types of shares. And then the types of shares here are referable to the various set of rights and liabilities associated with the shares. So the differences in the rights and liabilities will actually bring about the various categories or types of shares. So let us keep that in mind. Now, another point we should note with respect to company law in Ghana, and especially the concept of shares, is what you call the doctrine of no par value. No par value shares. What is that? According to section 43, the shares created or issued under this Act, Act 992, are shares of no par value. Now, when we say shares of no par value, let me quickly explain. We start from shares of par value. And then once we understand shares of par value, then the reverse is what section 43 is referring to. Now, when you go to United Kingdom, where we actually legally transplanted most of our laws from, including our company law, the practice over there is that when a company is incorporated, the total number of shares with which the company is registered are stated, and then the nominal price, the face value price at which the shares are supposed to be issued are also stated. So it may go like this, that this company is registered with 100,000 shares at 1 Ghana cedi per share. So this will be in the registered documents of the company at the time of incorporation. But in the UK, the practice of issuing shares is different from what really took place at the time that the company was registered. So therefore, in the registration documents at the Register of Companies, the narrative may be that this company was registered with 100,000 shares at 1 Ghana cedi per share. However, when shares are actually being given out to prospective shareholders, let's say that there's maybe out of these 100,000 shares, 20,000 shares have been issued. And then when they were issued, the shareholders paid 1 cedi, 20 pesos each, meaning that the actual price at which the shares were issued, the price is far greater than the nominal price, that is the face value, the price at which the shares were registered. On another occasion, maybe 30,000 shares of the 100,000 are issued. And this time, maybe the company is struggling, so the value of the company has come down. Now, a share is being sold at 80 pesos per share. Now, what is happening is that you see a discrepancy between the face value, which is like the nominal price of the share, and the actual price at which the shares are being sold. Now, where the shares are sold at a price above the nominal price, that is the price which was registered at the time that the company was being registered, we say that the shares have been issued at premium. Premium, that is above the face value, above the nominal value. On the other hand, where the shares are sold below the face value or the nominal value, we say that the shares have been sold at a discount or discounted rate. Now, Professor Agawa, when he was commissioned to make recommendations for adopting a unique company law regime for Ghana, he rejected the concept of par value and made the point that it was fraught with too much artificiality, just like I've explained to you, so that what is stated in the books is out of step with that which happens. So if that is the case, why not just allow the company to just register the shares? No particular face value or nominal value should be what? Should be stated. And at every point in time, we determine the value of the shares of the company according to how well the company is doing and according to the interaction of demand and what supply, as it were. So therefore, the concept of no par value, which is the regime we practice in Ghana, is that when shares are created, when you register your company with shares, do not dictate any initial price, any face value, any nominal price. So the shares are registered with no predetermined price. And then the price of the share is actually determined at the time that is being issued. So that is the concept of no par value. Do you have any difficulty, please? If you do, quickly raise up your hand before I continue. If there's any difficulty, quickly raise up your hand before I continue. Okay, that's good. No difficulty. Now we come to issue of shares. By issue of shares, we are referring to how shares are given out, right? How shares are given out. That is what we mean by issue of shares. The shares are actually, created by the company, but at what point are shares given out? So that, okay, let me see, has somebody got a question? Okay, somebody said I should go over section 43. Okay, good. Section 43 is simply to the effect that shares created in Ghana under our current law, and of course that has been the law since 1963, is that the shares are of no par value. And when we say shares of no par value, it simply means that the shares do not have any predetermined price. So that, if you remember when we were talking about, incorporation of company, you don't have a situation where you will say that this company is registered with 5,000 shares at 1 cedis per share. And that is actually stated and is going to be in the books as the nominal or the face value of the shares. No, we don't do that. All that we do is to say that the company is registered 5,000 shares. And because maybe the law says that the subscribers should have some shares as a requirement, so money will have to be paid. So the shares which are given initially may be given a certain price. But the fact that they're giving at those prices does not mean that throughout the life of the company, whenever shares are going to be issued, the shares will have to be actually be issued at a particular price with which the shares were registered in the beginning. But in the UK, that is why I said that to better understand Section 43, understand what the opposite of Section 43 is. And then it will be clear to you. And that is why I explained the concept of par value, right? That which is being prohibited by 43, that is par value. What is it? The par value, as I said, simply means that when companies are registered in UK, they are registered with predetermined price. However, in reality, when shares are being issued, when shares are being given out, being sold, they are sold not necessarily at the predetermined price. It may well happen, and it does, that they will be sold at a price above the predetermined price, in which case we say that the shares are issued at a premium, or they may be issued at a price below the predetermined price, in which case we say that the shares are issued at what? At discount. Now, in the light of these changes and these artificial changes, as it were, Professor Gawa, who made the initial recommendation for our Repeal Companies Act, which has largely been reenacted in Act 992, suggested that it was unnecessary for us to have a regime like that, to have a system where the company is registered with shares with certain predetermined value. When in reality, when they are being issued, they're issued at a different price. So let us have a neutral system. You register with the number of shares, but there's no predetermined value. There's no nominal value, as it were. I don't know if that assists the questioner. Okay, very well. Yeah, so we continue with issue of shares. We explain issue of shares to mean how the shares are actually given out, how the shares are given out to prospective shareholders. So that is what we mean by the issue of shares. But then let me make the point that we will come back. We are discussing Section 44 now, but we'll still come back to issue of shares when we are discussing public companies, especially limitation that they make to the public. But for now, Section 44 is to the fact that subject to the registered constitution of a company, different classes of shares may be issued in a company at the times and for the consideration that the company shall determine and shall be paid for at the times that are agreed between the member and the company. So a number of things are worth knowing from Section 44. So we have the general rules, right? And the general rules are applicable where a company did not have a registered constitution. And in case you've forgotten, when we are discussing the registration and corporation of company, we did make the point that the company has a choice either to have the default constitution, as in the second schedule, I think table I think B and so on, table C, D, depending upon the type of company. Or the company may decide to have its own tailor-made constitution, in which case we say that it has a registered constitution. But in a situation where the company does not have any registered constitution, then the position of the law is that first, different classes of shares can be created by the company. The company can create different types of shares or different classes of shares. Now, when we say different classes of shares, that is to say that the company can create different set of rights and liabilities associated with certain shares, right? So there are certain rights and liabilities which, let's say that shareholders in category A enjoy, which shareholders in category B do not enjoy. There are certain rights which shareholders in category C enjoy, and so on. So that is what we mean by the classes of shares or class of shares. Having certain rights and liabilities which are enjoyed or which are borne by only shareholders in a particular class. And if you're outside, you are not so included. Again, as to whether a particular class of shares exists or not, is very much dependent upon what the company decided to do when it was giving out shares. So at the time that it was giving out shares. So the class of shares that you have is determined at the time of you being given the share, not after. So that it's not the case that you're giving shares today, and next 2 weeks, the company will say that the shares that you were given, they now have these rights or these liabilities associated with them. No, that is not the law. The bundle of rights and liabilities associated with your shares should be made known at the time of the shares being issued to you. Again, the amount of money which will have you pay for the shares, what we call a consideration, or the cash equivalent of shares, which will have to be paid for the shares. And the time for paying it is something which is determined and agreed upon by the company and then the prospective member, the person being given the shares. So let us keep that also in mind. And that is why in a case which we have mentioned last semester, but although it was just mentioned briefly, the case of Asibe versus Adeshiman Gardens. Adeshiman Garden case. Who read it? Adeshiman Gardens Limited against Asibe. Let me put it here for you. Just a second. Do you see what I've written? No, no, okay, if you don't see, let me see, let's see. This, okay, you don't see. Well, I'm sharing the, let me share this again. Let me just come. Did you see the case? Okay. Two 2004. Can anybody confirm in the chat if you see what I've just written? Okay, all right. Yeah, so in the Adishman Gardens Limited, all right, thank you. In Adishman Gardens Limited against Asibe, a very interesting development. The company, Adishman Gardens Limited, of course, a Kumasi-based company. Adishman Gardens used to be a very interesting place in the 90s. I don't know if it's still really there. So Adishman Gardens Limited was incorporated with 1 million shares. And then the constitution of the company showed that there were 4 subscribers, including Mr. Peter Osei Asibe, who had subscribed for 200,000 shares out of the 1 million shares. And when the case came before court, it was alleged that Mr. Asibe did not pay for his shares. And the various correspondence between the company and Mr. Asibe showed he was, let me see, somebody else writing something. Good. Say that shows that Mr. Asibe was referred to as a nominal shareholder. And why did the company refer to Mr. Asibe as a nominal shareholder? Because according to the company, Mr. Asibe had not paid for his shares. So he was offered 20% shares, and then he was asked to pay for it at the current value. So Mr. Asibe sought to also challenge his status in the company as a share. The company did not want to recognize him as a shareholder in the full sense of the word, and they only call him a nominal shareholder. So when you say something is nominal, nominal means that just in name, but not in reality. Now, the matter was fought right up to Supreme Court, and the Supreme Court took the view that if you look at the relevant legislation at the time, which governs who a member of a company is and subscribers and all that, there was nothing like a paid up, a shareholder who is a shareholder and then someone who is not paid up, and for that matter, just a nominal shareholder. And the court will make the point that what is really important is whether a person's name has been entered in the register of members. If your name has been entered in the register of members, then you are a member of the company. And if it's a company limited by shares, your name is entered in the register of members, you are a shareholder. However, the fact that you are a shareholder does not mean that you are a fully paid up shareholder or not fully paid up shareholder. That is a matter which will be determined by the type of agreement you had with the company. If at the time the company was giving the shares to you, the company asked you to make upfront payments or to finish paying by a particular date and so on, then the company will have to go by that. And where you have, for example, defaulted in paying, when the company has actually made a legitimate call on you, when we say the company has made a call on you, that is, the company has served a demand notice on you to come and pay for your shares. If you do not do that, then the company will be entitled to exercise its right to either cancel the shares which were issued to you or as it were, to see you and recover the payment if the company is so minded. So please, if you haven't read Adishman Garden Limited against SEB, read it again. Then just before we move on, another point to note also about section 44.1 is that where, for example, the company is being liquidated, if you are a shareholder and you are not fully finished paying for your shares, the liquidator can always take steps for you to pay for the unpaid value of your shares. And that is why if you take section 44.2, you'll be told that on winding up of the company, every past and present shareholder of the company is liable to contribute to the assets of the company to the extent referred to in section 40. What is section 40 saying? Section 40 is telling us the concept of limited what? Liability. That if you are a shareholder in a company, your liability does not go beyond the amount of money which you have to pay in respect of the shares issued to you. So therefore, where shares have been issued to you, but according to the terms of the issue, you are not supposed to have finished paying all until a particular time, and then the company is, for example, wind up. The company is being folded up, is closing down. You will be called upon to come and pay the outstanding value, the outstanding balance in respect of the shares which have been issued to you. So let us keep that in mind. Now we want to discuss a very important aspect of shares, payment of shares. Payment of shares. Payment of shares, very important because, as I indicated earlier on, somebody got. Okay, so Francis. Francis has a question. Yes. Yes. Francis, you can mute yourself.
Hello, sir.
Yes.
Yeah, my question is, assuming the period that you were given to during the registration, you are supposed to pay the shares. If the time is not due and the company is winding up, are you still supposed to pay?
If the time is not due and the company is winding up. Yes?
Yes, sir. If the time.
Yes.
Yeah, yes, please.
Yes, you will still have to pay if the terms
sir.
of the issue also said that you're supposed to enjoy dividends even when you have not finished paying for the shares.
Okay, sir.
Yeah.
Okay, sir. Thank
because if you have the shares issued in the company is supposed to represent the amount of investment which shareholders have made in the company. So therefore, at every point in time, if we have X number of shares, then when you know the value of the shares, we should know the amount of money which are put in the company by shareholders. And that is why if the company agreed that you can pay your shares, maybe part of it at a later date, that one is just a special dispensation which is given you. But that has got nothing to do with when your liability will actually accrue. Or you think it should be different, Francis? Francis? Is it there? Okay.
Yes, I thought maybe because the period that was given to you is for a purpose. And therefore, if the time is not yet due and the company is winding up, at least there should be some other form of any other thing that you are supposed to do other than paying the money. Maybe after that particular time, you were still not ready in terms of the payment. Sir.
Okay. All right. So before you lock yourself, he's hung up. What happens is that as we have been discussing, that when it comes to issue of shares, right, in terms of section 44.1, pay attention to here. Agreed So the terms, the rights and liabilities associated with the shares, you've also seen that in 42, 42.2. Like the rights and liabilities attaching to the shares are dependent on the terms of issues.
Yes.
So if in your case,
Yes, please.
it was the understanding between you and the company that not until you have fully paid, you're not going to be given benefits or dividends in respect of all the number of shares you'll be given. And that if you are going to pay dividends at all, the dividends will be pro rata according to the portion of the shares that you have paid for. Assuming that is the agreement you struck with the company, then that will be it. On the other hand, if there is no such special arrangement, then the orthodox thinking is that once you're a shareholder and you haven't finished paying for the value of the shares, despite the fact that the time for payment for the unpaid balance has not arrived and then the company is liquidating, you be called upon to pay.
Yes, sir. I'm grateful, sir.
Right. So we come to payment of shares. The general rule, which we have in section 45, is that anytime shares are issued, the shares are supposed to be issued in return for valuable consideration. Valuable consideration, that is the first rule. Anytime shares are issued, the shares are supposed to be issued in return for valuable consideration. And two, this valuable consideration may be paid upfront or may be payable, that is, may be paid for in future. And the point 3 to remember in terms of section 45.1 is that it is permissible for the valuable consideration not to be money. The preferred valuable consideration is cash. However, the law also permits non-cash consideration to be given as a mode of payment for shares. And we're discussing 45.2 very soon. But before we discuss the non-cash valuable consideration, which may be paid for shares, let us remember one important exception, which we call capitalization. Another word for capitalization in ordinary man's language is what we call the bonus share or bonus issue. When we talk about capitalization, if you go to section 77, it's explained in detail there, but we'll discuss it again. So capitalization is where shares are issued in proportion to the amount of dividend which a shareholder will have been entitled to. So first and foremost, capitalization applies to only existing shareholders. Capitalization presupposes that you are a shareholder. You have shares in the company, and the company is going to give out more shares, right? Now, because you are a shareholder, and then the company is going to give out more shares, but the company does not want to go outside the existing shareholders and take fresh money. Now, you, the existing shareholders, the company has made profits, and the profit is supposed to be paid to you as dividends. And instead of paying the profit to you as a dividend, the company takes the decision that we are going to give more shares to each existing shareholder. But the number of shares that a shareholder will get will be in proportion to the amount of money which will be paid to him or her as a dividend. And because of that, when the shareholder is given the additional shares in proportion to the amount of dividends due him, that shareholder will not have to pay any money to the company again, either by way of cash or by non-cash consideration. And of course, the logic is simple. The company was supposed to have paid money to this shareholder. And instead of paying money to the shareholder, the company decided to plow back to sink the money back into its operation and say that in return for that, we are giving you more shares. And that is what Section 45(1) is saying, that except on capitalization issued under Section 77, shares shall not be issued otherwise than for valuable consideration or payable, unpaid or payable to the company, and unless otherwise agreed, shares shall be paid for in cash. So get this thing straight. Payment for shares. Okay, somebody's hand is up. Gordon. Yeah, Gordon. Oh. Yes, Gordon, yes, you can speak. Oh, it's Gordon. Okay, no problem. Just anyway, let's move on. Yeah, so Section 45(2), where a company agrees to accept payment for shares otherwise than wholly in cash, the company shall within 28 days after the allotment of the shares deliver to the registrar for registration a contract in writing, duly stamped, evidencing the terms of the agreement and the true value of the consideration, or if the agreement has not been reduced to writing, particulars in the prescribed form of the agreement duly stamped as if it were a written agreement. Now, I have taken my time to read every word of Section 45(2) for a purpose. As I speak now, there is a very important case pending before the courts in Ghana concerning Section 45(2). So maybe in the course of the year, we have like the judgment. And the case is just turning on the fact that somebody is saying that the company issued shares. Somebody is saying that the company issued shares to it, and the shares were supposed to be a return for non-cash consideration. That's what the person is saying. That yes, I did certain services and so on and so on. And the company gave me shares in return for that. Now the company is denying that. And then this person is insisting, and that is the case. And the case now is turning on whether there is the, what we call the agreement, which is duly stamped, evidencing the terms. I mean, there's a document which is duly stamped, evidencing the terms of the agreement. And this has generated a lot of controversy. But coming back to Section 45(2), what the lawmaker is telling us is that much as it's preferable that when shares are issued, the shares should be paid for in cash, it's also permissible for the company to take non-cash consideration. However, the lawmaker would like the company management to be transparent about agreement under which the company accepted to issue shares in return for non-cash valuable consideration. And that is why 45.2 says that when there is any such issue of shares for non-cash consideration, within 28 days after allotment of the shares, the company is supposed to submit details, particulars about the transaction, or better still, the agreement itself under which the company accepted non-cash consideration. It should be stamped, and same should be submitted to the registrar of companies. Now, this is for good reason. And the reason has to do with ensuring that those who are in charge of the company will not indulge in unacceptable practices of giving shares as gifts to themselves or to their cronies and deceive other shareholders that those people have also acquired shares in the company, when in reality, they have not given anything to the company by way of cash or by way of service or some other kind of arrangement. And that is why the lawmaker said that, okay, we want to have an evidence of whatever the person did, whatever the person has given to the company, for which reason the company is giving the shares. Now, when the company is being wound up, or when the company is being liquidated, as it were, and a liquidator is appointed, the liquidator can go through the books to find out information regarding shares which were given by the company in return for non-cash consideration. And where the liquidator realizes that the value of the agreement is far less than the number of shares which were given, the liquidator can take steps to have the shares revalued, and then the person will be compelled to pay the difference to the company. Yeah, so that is the rationale for insisting that the agreement under which the company accepted non-cash consideration should be registered with the registrar of companies. Let's keep that in mind. But of course, one would say that, okay, if that is so, then since capitalization also does not require payment by the shareholder, you must also go through the requirement that you should register the agreement. But if you look at section 45.3, section 45.3 is actually creating an exception that when it comes to capitalization issue of shares, that is bonus issue of shares, it is not necessary for the procedure which is usually followed, where the company issues shares for non-cash consideration to be followed. So let us keep that in mind. And the point I made regarding the rationale for insisting that the company should submit the agreement for non-cash consideration to the register of companies, we have it under section 45.4, that the statement in the agreement of the value of the non-cash consideration is sufficient evidence of the true value of the consideration. But when a company limited by shares is in the course of being wound up, under the Body's Corporate Official Liquidation Act 1963, which is now repealed by the Insolvency and Corporate Restructuring Act. The liquidator or creditor may apply to the court, and if the court is satisfied that the true value of the consideration was less than stated, it may direct that the shares shall be treated as unpaid to the amount of money that it shall direct. Yeah, so that is the wisdom in saying that the agreement for non-cash consideration should be registered with the registrar of companies. Now, when shares are issued by the company, there's also the need for certain documentation to be done as a way of enhancing transparency in dealings of the shares of the company. So there's a document we call return of issue. Return of issue. So if you look at section 46 of Act 992, we are told by return of issue that where a company issues shares, other than a reissue of treasury shares as defined in section 63 of 61, the company shall, within 28 days after the issue, deliver to the registrar for registration a return in the prescribed form, showing us at the date of the return certain information which is actually spelled out there. So A, the amount of stated capital attributable to each of the items specified in section 68. B, the number of the authorized shares of each class. C, total number of issued shares of each class and the amount of money paid for the shares, distinguishing between the amount paid in cash and then the amount paid otherwise than in cash. In the case of company limited by shares, the amount of money remaining payable on the shares, distinguishing between the amount presently due for payment and the amount not yet due for payment. And D, the total number of treasury shares of each class. Now, this return of issue, which is provided for in section 46, is very important. Its importance lies in the fact that it's supposed to make, everything the company has done about the shares be open. So the company is supposed to report its activities regarding shares. So when you have issued 28 days after issuing shares, the company must update its information at the Register General Department, the Register of Companies now. And how is the updating done? The updating is done by sending a document called Return of Issues. And over there, the company is supposed to tell us, okay, so if you are talking about the stated capital, that is amount of money, right? Amount of money which the company has actually raised by its shares. How much is the stated capital now? How much funds has the company actually generated through its shares so far? Then the company is also supposed to tell us what is the total number of authorized shares of each class. If you have different classes of shares, for each class, what is the total number? And then out of the total number of the shares in the class, how many of them are issued? Mind you, the total number of authorized shares is not equal to the total number of issued shares. Of course, it can be equal, but not necessarily all the time. You can have the total number of authorized shares being greater than the total number of issued shares. Because the fact that you have registered shares and then the shares become what they call like the authorized shares. Authorized shares means that is what the company is authorized to issue them, because that's what is registered. It does not mean that the company is immediately going to issue all those shares out. The company may issue some out and the others will still remain on issue. Now, if that is the case, when the company is reporting to the Register of Companies about shares issued, we want the company to tell us of the total number of registered authorized shares, how many have you issued in respect of each class of shares? How much money did you make from the number that you have issued in respect of each class of shares? Now, if some of the shareholders have not finished paying, let us know when another agreement, when are they supposed to have finished paying, and so on. And again, we also like to know the number of treasury shares from each class. When we say treasury shares, very soon we'll be discussing what we call preference shares or preferential shares. And you notice that for redeemable preference shares, it is possible for the company to exercise its right against the shareholder, where the shareholder has, for example, defaulted under the terms of the issue, and either cancel the shares or acquire the shares back and so on. So where a company previously issued shares and then through some means permitted by law, the shares come back to the company. The company is supposed to keep the shares in a space, what you call treasury. They can be reissued later on. And of course, as you have appreciated by now, whenever whenever rules are given, and then the rules are not complied with respect to the company, sanctions follow. So Section 47 prescribes the regime for where the company has defaulted in complying with 45 and 46. 45, very important, the rules of payment for shares. And then the 46, the return of issue. That is the reporting requirement by the company to the Registry of Companies as far as its dealings in its shares are concerned. Now, Section 48 gives us more information regarding what it means to pay for shares issued to you in cash. So what does it mean to say that payment is made in cash for shares issued? So Section 48(1) is to the effect that shares have not been paid for in cash, except to the extent that the company has actually received the cash for the shares at the time of or subsequent to the agreement to issue the shares. Yeah, so we have like a very straight meaning. So we are talking about cash, payment in cash. And payment in cash means that actual money has hit the company when the company gave out the shares, or after the company has given out what? The shares. So that is what it means to say that the shares have been paid for in cash. Now, 48(2), where shares are issued to a person who has sold or agreed to sell property or agreed to render services to the company or to persons nominated by that person, the amount of money of a payment made for the property or services shall be deducted from the amount of cash payment made for the shares, and only the balance shall be treated as having been paid in cash for the shares, despite an exchange of checks or any other securities for money. So 48(2) is just giving us more permutation where shares are given to someone who has agreed to sell property or something to the company or do something for the company, and the person has nominated someone to do that for him. Then we want to find out, okay, now the company is going to pay money to you because you have agreed to sell something to the company, or vice versa. So we want to know the money. Your money is with the company, or the company money is with you. So how do you determine in respect of the shares which are issued to you? How do you determine whether you have actually paid for in cash or you have not paid for it in the light of the related transactions? So that is the point section 48.2 is making. Now, 49 talks about the various classes of shares which the company may have. And don't forget that we have already made the point when we're discussing section 42, yes, when we're discussing section 42.2, that the company may attach rights and liabilities to shares. And so 49 is reminding us that, yes, it is possible for you to have a classification of classes of shares. So 49.1 says that the registered constitution of a company may provide for different classes of shares by attaching to certain of the shares preferred, deferred, or any other special rights or restriction, whether as regards dividends, voting, repayment, or otherwise. In other words, section 49 is building upon section 42, 2, who tells us that you can choose whatever rights and liabilities you want to attach to any shares. And if you do that, then if the rights and liabilities you are giving to a particular set of shares are not available to other set of shares, you have created class of shares with class rights. And class rights are those rights which are enjoyed by shareholders having their shares within a particular class or category of shares. And 49 is giving us instances, examples of such classes. And that is why it's saying that, yes, the company can create what we call the preference shares or deferred shares, or any other description that you have. And this may apply to dividends, voting, repayment, or otherwise. Now, when it comes to dividends, we have noted that in all companies rated by shares, shareholders are entitled to partake in the profits of the company when profit is made, and then the company decides to declare a portion of the profit as the dividends. Now, when dividends are declared, the amount which a shareholder will get is very much dependent upon how much profit the company made and how much the company decided to declare dividends. Now, what that means is that if the company did not make much profit and you have a lot of shareholders, that profit will have to be shared among all the shareholders. You may just get a very small or a paltry sum, as it were. But there are some shareholders who do not want to take such risk, and they may want to be assured that for the shares that you are given, you've acquired in the company, whenever dividends are declared, you are going to be given this agreed percentage of dividends or something like that. So we have shareholders who have been guaranteed or who have been given a priority in terms of the amount of dividends which will go to them whenever dividends are declared, and so on. So in that case, we have preferential shareholders in respect of dividends. But what happens is that where so much profit has been made, and part of it has been declared dividends and all that, this preferential shareholder in respect of dividends will get his dividends. But the dividend that he will get is just the fraction, just the percentage, which he's entitled to as a preference shareholder. Now, after he has gotten his agreed portion, he will not participate in the extra dividends, even if all other shareholders get theirs. He will not participate. Only the ordinary or equity shareholders will share whatever is left. Now, we can also have preference shareholders in respect of voting. Under another circumstance, each share of the company carries or commands one vote. So one share, one vote. However, the company can arrange its affairs in such a way that for certain types of shareholders, they may be given special voting rights so that their votes count more than one or something like that. So where you are preference shareholder in respect of voting, that is to say that you'll be given a certain preferred status, a certain special treatment when it comes to voting. So that just as each shareholder's share may count only as one vote, yours may count many more according to what is prescribed. Or you can also have preference shares in respect of repayment. So there are some shareholders, they do not want their money to stay. Somebody said, okay, Gordon, and I want to ask a question. Okay. No, Gordon, I think Gordon, I think that you need to check the. I don't know if you're using your phone or your laptop. It appears your audio is not activated, and that is why. Yes. All right. Yeah. So just before the interjection, the point was being made that we can also have a preference shareholder in respect of repayments. Now, there are some preference shareholders who may want to put their money in the company for a defined period. At some point, they may want the company to take the shares back and give their money to them. So we have what they call the redeemable preference shareholders. As the name suggests, redeemable. So they can ask the company to take their shares and give their money back to them. So some shareholders may also go for that. In that case, they become what we call like the redeemable preference shareholders, as it were. But these are just some of the possible permutations or classification which one may have for shares. You can have so many things. The bottom line is that the rights or privileges which you are attaching to the shares are not available to be enjoyed by other shareholders who are not in that particular category of shares. And those privileges or rights can be anything. So the configuration of the preferential treatments are actually non-exhaustive. Now, 49.2 is to the effect that shares are not of the same rank unless they rank at the same rate for all purpose. That is to say that shares can have different rights and liabilities. That's the general rule. And unless the company has stated that all its shares shall rank at the same rate for all purposes, in which case there's no differentiation in terms of rights and liabilities. Now, since we have class rights, which you have understood as rights that are enjoyed by shareholders having shares in a particular class of shares, to the exclusion of all other shareholders who are outside that class. We can also have variation of class rights, variation from the word vary, that is modification or changes or alteration. So section 51 is to the effect that where at any time the shareholders of a company are divided into different classes, the rights attached to a class shall not be varied unless otherwise expressly provided for in the constitution of a company. So section 51 is trying to protect class rights. It's trying to protect rights of shareholders in a particular class and say that once you have created that class and for that matter, the rights, privileges, and liabilities associated with that class, you cannot change it at will. You can only change it if the constitution of the company made provision for that. If the constitution of the company did not make provision for that, you cannot vary the class rights. And that is why 52 says that where the constitution of a company forbids a variation of the rights of a class or contains provision regarding that variation and expressly forbids an amendment of the provision in respect of the variation of rights, the rights shall not be varied, and the provision for variation shall not be amended except with the sanction of the court under a scheme of arrangement in accordance with section 239. Now, there is something I will propose for you to pay attention to at even this stage, before later when we discuss mergers, amalgamations, and arrangements. So what we call arrangements sanctioned by court. And that is what section 52 is referring us to when it makes reference to section 239. Now, the constitution of a company may state expressly that under no circumstance shall the rights of class of shareholders be changed or verified. Now, where that is the case, it does not mean that it's a dead end. Nothing can be done at all. What that means is that you cannot use procedure of the constitution of the company to bring about the variation or the modification. You need to actually involve the court, bringing yourself within the procedure under section 239, in which no resolution be passed, then the resolution will have to be taken to the court for the court to give it blessings and so on and so forth. So that is what we mean by a scheme of arrangement sanctioned by court under section 239. And as indicated, it is one of the remedies where the constitution of the company has actually forbidden variation of a class right, and yet the need arises for the company to vary class rights. Then the company may have recourse to section 239. But if we look at the section 50 subsection 3, we are told that except as provided in subsection 2, and what is provided in subsection 2? Subsection 2 is saying that it is possible for the company to completely forbid variation of the class rights. Now, where that is the case, where that is not, that is not the case, that is where the company has not expressly forbidden. That is what we mean by the except as provided. Then, a company may, by a special resolution, amend its constitution by inserting in the constitution provision regarding variation of the rights of a class, or by modifying terms of those provisions. So the company can pass a special resolution. A special resolution is a resolution in respect of which the company gave notice when it sent out the notice convening the meetings, and then when the meeting is held, about 75% or 3/4 majority of the company will give their consent to that resolution. So that is special resolution. So 54, an amendment under this section requires the prior written consent of the holders of at least 3/4 of the issued shares of each class, or the sanction of a special resolution of the holders of the class of the shares of each class, and shall be deemed to be a variation of the rights of each class. So if you have a class of shareholders and they enjoy certain rights by virtue of being shareholders in that class, if you want to change those rights enjoyed by that class of shareholders, what 55 is telling us is that you shall, 54 is telling us is that you shall actually have to get approval of 3/4 of those who enjoy that right. The 3/4 of them will say that, yes, we agree that our rights can be tempered with, our right can be varied. Then the process can go through. The process can go through. Now, 56, a resolution of the company, the implementation of which will have the effect of A, diminishing the proportion of the total votes exercisable at the general meeting of the company by the holders of the existing shares of each class, or B, reducing the proportion of the dividends or distributions payable at any time to the holders of the existing shares of the class, is for this purposes of this act, a variation of the rights of that class. We are also giving other ways in which variation of class right may come about. And two typical examples are provided, apart from the usual ones, that if the number of votes which group of shareholders are supposed to have when the company is having a general meeting, if you get the company to pass any resolution, which will, for example, modify or affect the number of votes which may be cast as general meeting and all that by a certain group of shareholders, that is only treated as example of variation of class rights. And again, where you're also trying to say that henceforth, these shareholders shall not get this quantum or this percentage of dividends, which ordinarily they are entitled to. Now, if you pass any resolution seeking to achieve that, that will also be treated as a variation of what? Class rights. And we come to 51. So far, we'll be talking about preference shares and all that. Now, section 51 actually unveils the two types of shares we have, which we see various permutations of one of them so far. So 51.1 is quite significant in reminding us that in this act, that is in Act 992, preference share means a share which does not entitle the holder of the share to a right to participate beyond a specified amount of money in a distribution, whether by way of dividend, a redemption, in a winding up, or otherwise, and any other share shall be referred to as an equity share. In other words, what Section 51.1 is doing is that it has told us various ways in which preference share may be created. And when it finishes, it says that if you are any other share not falling within the ways preference shares come about, we call you an equity share, or what we call ordinary share. So equity share, ordinary share are the same. They're actually interchangeable. Ordinary share, equity share. So what does 51.1 actually mean by the preference share then? Now, as we have noted that for some shareholders, they may want to be assured of a specified amount of dividends whenever dividends are declared. Or they may want to be assured of a specified amount of the income or the distribution, the assets of the company. You know, when we say distribution, we are talking about where the company is, for example, winding up. Once the debts and liability of the company have been paid, and we still have surplus assets of the company left, because the company is actually closing down, is going to be dissolved and all that, the surplus assets will have to be shared among shareholders. And that is what we call a distribution, okay? Distribution. Now, when you get to that stage, if you have a preference shareholder in respect of distribution, what that means is that that preference shareholder is going to be given a certain specified amount of the surplus assets available to be shared for all shareholders. He will be given an assured specified amount first before all other shareholders will get. Or we can also have a preference shareholder who will say that I do not want my money to stay in the company forever. At some point, I want to be able to go to the company and tell the company that take your shares back, give my money to me. So that is preference share in respect of redemption. So if your share does not fall within any of these categories, any of these permutations, then you are an equity share. You are an ordinary share. As I said, equity share, ordinary share are actually interchangeable. So 51.2, a share that is not a preference share shall be referred to as what? As an equity share. And 51.3 gives us more information about preference share. But the information which is telling us is that it's not so much about the name, right? And that is why 51 will say that the meaning of preference share under subsection 1 shall apply to whatever name the company may designate in this constitution. So you don't need to use the magic word or magic phrase, preference share, before we'll say that this company has got some preference shareholders. No. It is functional approach, functional significance. In other words, we look at the substance of the rights associated with your share before we can tell that you are a preference shareholder or you are not a preference shareholder. So let's keep that in mind. So we look at the right associated with your share. And that is why 51.3 saying that it's not about the name. Just as when we are discussing directors, It's not about you being given the word director before we treat you as a director, but you look at the substance of what you are doing in relation to the company. So we look at, so here too, it's not so much about you being called preferential, which really matters. You can even call you golden shareholders. No problem. What is important is that if we look at the substance of shares, or I mean substance of rights, which you exercise and enjoy against the company by reason of the shares you have, are you special in the sense that other shareholders do not enjoy those rights? If the answer is yes, then you are a preference shareholder, even if the name preference share is not used for you. Any question before I move on? So let's discuss the suspension of voting rights of preference shares. Now, before we discuss section 52, let's remind you again that under the law, under 992, every share carry one vote. So let's keep that in mind first. Now, let's look at section 52.1. Despite section 34, the right of holders of preference shares to attend and vote at the general meeting of the company may be suspended on conditions. So as I indicated, under normal circumstances, each share or each shareholder is entitled to one vote. And being entitled to one vote also means that you're entitled to attend meeting, you're entitled to be given notice regarding meetings and all that. However, the law permits that under appropriate circumstances, the meeting attendance and meeting voting rights of shareholders could be suspended, could be put in abeyance. So let's look at 52.2. Despite a provision to the contrary in the constitution of the company, preference shares carry the right to attend general meetings and on the poll at those meetings for at least one vote per share in the following circumstances, but not otherwise. So look at it. We are being told that, yes, preference shareholders, under certain situation, your right to attend and vote at meetings may be restricted. But even when there are restrictions in force, those restrictions will not apply to certain types of matters which are being decided in the company. And what are those? Two, but not otherwise. A, on a resolution, during the period that the preferential dividend, a part of the preferential dividend remains in arrears and unpaid. The period starting from a date not more than 12 months or a lesser period that the constitution of the company may provide after the due date of the dividend. In other words, even where the right of a preferential holder to attend and vote at a meeting has been suspended under permissible provisions of the company's constitution. Now that suspension will not apply if the company was supposed to have paid dividends to this particular preference shareholder and the dividend has not been paid and 12 months have already what elapsed and all that, then automatically, if any resolution is being passed during the period that the company is owing you, for not having paid you the agreed preferential dividend, you are entitled to attend and vote at the meeting. Then the second scenario in which a preference shareholder whose right to attend and vote at a meeting is suspended will still be able to attend and vote is where the company's meeting is going to deal with a resolution which varies the rights attached to those shares. So even where you are suspended from attending and voting at the meeting, and yet the particular issue on the table before the company is a resolution to vary the rights attached to your shares, you will be entitled to attend and vote, notwithstanding the ongoing suspension of your general voting right as a shareholder. The third scenario is on a resolution to remove an auditor of the company or to appoint another person in place of that auditor. So here too, a suspended preference shareholder will still be able to attend and vote. Or D, on the resolution for the winding up of the company or during the winding up of the company. Now, apart from the circumstances in section 34 and subject to what we are discussing, preference shares carry the right on the poll general meeting of the company to one vote, only in respect of each share. So this is what we've discussed already, that's the general rule, and it applies to all shareholders, not only preference shareholders. Now let's look at the subsection 4. We'll finish at 7:30, so don't worry. A special resolution of a company increasing the number of shares of a class may validly resolve that an existing class of preference shares shall carry the right to the votes specified in subsection 3. Additional to 1 vote per share, as shall be necessary in order to preserve the existing ratio, with the votes exercisable by the holders of those preference shares at the general meeting of the company bear to the total votes exercisable at the meeting. So, what 50.24 is telling us is that the company which has created preference share and has also provided that under certain situations, it may suspend the right of the preference shareholders to attend and vote at the company meetings, of course, except those instances which the law has said that even where they're suspended, they can still vote, maybe regarding where there's arrears, with respect to their dividends, or where you are going to remove an auditor, appoint an auditor, or where you are going to vary their class rights. Now, apart from these scenarios, the company can, actually put or give preference shareholders an additional vote. So in addition to their usual vote, they may be giving additional vote that when the matters that we have gone through, for example, maybe dividends remain unpaid, appointment of auditors, removal of auditor and all that, then we can say that when those situations exist, preference shareholders should be given additional vote, and this will enable them to actually ensure that their ratio of having a certain sway upon corporate decision makings remain intact, despite the fact that the company decided to increase or bring in more shares, as it were. The company may want to increase the number of shares and all that, but the company must make sure that the company does not create more shares, which would ultimately dilute somebody's majority shareholding, or would dilute someone's right to have more votes during meetings. So long as those matters are safeguarded, then nothing prevents the company from increasing the number of shares of the various class. And just before I continue, on that point I made, later on we will discuss what we call the principle or the doctrine of preemption, right? A preemption issue, which simply says that where a company is going to issue shares, let's say that the company has 500,000 shares, that is the registered number of shares or the authorized number of shares. The company has already issued, let's say, 300,000 shares, right? So it's left with 200,000 shares, which are unissued. Now the company needs more money. So the company decides to issue some of its unissued shares. Now the doctrine of preemption or preemption issue says that the company must give the first option to existing shareholders in order to safeguard the balance of shareholding, the balance of voting right, and so on between existing shareholders. Because if at the moment I am the majority shareholder, right? Or I just gave you an example that maybe somebody is in the top 10 of a particular bank and so on. And then the bank decides to issue more shares. Preemption doctrine requires that the existing shareholders should be given the first option to come and acquire the shares. And when they say that they are not interested, before outsiders can be asked to buy the shares. So that this preemption issue enables whatever privilege majority status which existing shareholders enjoy to be maintained and not to be diluted. Now 52 subsection 5, for purpose of subsection 2, if you remember, 52.2, we talk about the fact that despite the fact that a preference shareholder might have had his right to vote, to attend and vote at meeting suspended. Nevertheless, where there's an arrears of rent of dividend payment, where the company has defaulted in paying the agreed dividend to this particular shareholder, even when his right to attend and vote has been suspended, he will still be able to attend and vote a resolution. So we want to understand, what does it mean to say that the arrears, the dividend is in arrears, or the dividend is due? And that is where section 52.5 becomes relevant. A dividend is due, A, on the day immediately following the expiration of the year or other period, or B, where a company has a registered constitution on the date appointed in the constitution for the payment of the dividend for a year or to other period, whether or not the dividend has been earned or declared. So section 52.5 is giving us the formula for making computation or determination as when the dividend became due. Any question? Okay, no question. Move on. So let's look at the votes of equity shares. So far, we'll be saying a lot about rights of preference shareholders, especially the voting. 53.1, despite a provision to the contrary in the constitution of a company, equity shares carry the right on the poll at a general meeting of the company to one vote only in respect of each share subject to section 34. Now we have already made the point that each share carries 1 vote. However, when we're looking at section 52, we also came across a possibility of giving more voting rights to preference shareholders. And that is why section 53 is telling us that as far as equity shares are concerned, ordinary shares are concerned, each share carries or commands only 1 vote, and no more, no less. Now, 53.2 also contemplates the situation where there can be changes in the rights of issue preference shares. And those changes are where you have, you talk about a variation of class right, if you remember. So variation of class right, where there has been a variation of class right of issue preference share, so that they become equity shares, then they will tend to be an issue of equity shares. In other words, we saw not too long ago that for preference shareholders, if the company succeed in getting a resolution passed so that their voting rights, which they are ordinarily entitled to, are somewhat modified, then that is reckoned as class rights variation, or variation of what? Class rights. And when it happens that way, despite the fact that originally they were issue preference share, now they will become equity shares. That is what 53.2 is telling us. Somebody's video as well. Has it got? Does the person want to speak? Okay. Yeah, pretty. Unmute yourself. Somebody call Pretty V, you can unmute yourself. Yeah, so just before you go, let's discuss canons of construction of class rights. Okay, I will draw the curtain down on that for tonight. I don't know how your time is this weekend. I mean, this week, probably tomorrow evening. Can you do 1 hour in the evening?